Good afternoon. Welcome to another edition of Legal Access. Today we're going to be talking about a very lively topic whenever we do this, HOA law. You can kind of look at this episode here today as being maybe your pregame show for tonight's football game, kick off the season between the Chiefs and the Ravens right here on WMBF. So if we're part of your tailgate celebration, we appreciate you making time for us here today. But since we are going to be talking about HOA law, get your calls in early because the phone lines will jam up pretty quickly. We want to get you in before the time is up in about 30 minutes. Our phone number is up on your screen, 843-848-8080, 843-848-8080. Here on the panel to answer those questions about HOA law here today from the Inland Law Firm is Mark Napier. Hey, Mark, how you doing today?
All right, how are you today?
And joining us for the first time from the Mullins Law Firm is Jared Owenby. Hey, Jared.
Hi, how's it going?
Going good. You'll be in for a lively 30 minutes here. We're just telling you.
Looking forward to it.
All right, before we get started with phone calls, let's go ahead and ask the questions. According to the Department of Consumer Affairs in South Carolina, Horry County leads the state in the number of complaints about their HOAs. Why is that? Why do you think that is?
Well, I don't know, Mark. I think the area we're in has a lot more HOAs that affect property here than maybe other places in the state.
That's true. I mean,
Yeah.
we were inundated with associations, and so and you have that applies to whether it's homeowners association for single family housing
Right.
or for condominium associations as well. And of course, there's lots of condos here on the beach.
Okay, since we lead the state in the number of complaints, what's the number one complaint that people come to you about their HOAs?
Judging from the consultations that I have with potential clients, it's usually an arbitrary enforcement, or my neighbor put up a fence and it's straddling the line, some sort of an encroachment issue. But a lot of that really is the at least perceived arbitrary enforcement of the HOA documents.
Yeah, I would say that, and then my association's doing nothing. My board is doing nothing.
Yeah.
How can I make them do something?
Or the special assessments,
Right.
or the insurance assessment, which has become a bigger problem now.
Right.
Well, to go back to your question there, Mark, I mean, that's a question we normally get on a regular basis here. Again, the phone lines are open, 848-8080, as we're talking about HOA law here today. If their association is doing nothing, if they're supposed to be doing something about whatever situation, how do you get your HOA to actually get off their butt and do something?
Well, there are requirements. Sometimes they're doing something you don't know it.
Right.
Because in South Carolina, for instance, the board, unless it says it in your documents, the board doesn't have to make their meetings public. And so if the board of directors could possibly be having meetings and you don't know about it. Now, the minutes should be available, certainly, of the meetings, but sometimes you don't know. And otherwise, what I tell people to do is, look, if you don't like the way the association's being run yourself. run for office.
Which is, incidentally, that's usually what the circuit court judges
Right.
have kind of advised people is, well, this is a quasi-political process.
Right.
And you need to get involved if you don't like the direction it's moving.
Exactly.
But in the time between your complaint today and whenever the next election is going to be in a year and a half, then that leaves 18 months when nothing's being done, though. So,
Well, and it's certainly a problem. You get like-minded people who also have the same complaint, and you contact the management company, contact your board members, and let them know of your complaint. I mean, going to an attorney should be the last resort
Right.
for something like that, because if we get involved, and we can write a letter just as easy as they can, but if it's ignored, it's going to take a lawsuit.
Right.
And then you're going into the same time frames that you just referenced.
Right.
I mean, nothing is fast when it comes, unfortunately, to filing a lawsuit.
what is fast is being able to get you on the air and answer your questions. The phone number's on your screen if you have any questions about your HOA or what they should or should not be doing, or if you're a member of the board and you want to know what you should and should not be doing. Let's go to Florence for our first call of the day. Clarice is on with us. Hi, Clarice. What's your question today?
Hey, mine is more regarding homeowners insurance. I had a storm that came through back in December of last year, and I was actually trying to get the insurance to pay the claim because I do have the coverage. And they keep not responding to me, and I can't get anyone on the phone. I got in touch with South Carolina Insurance and the National the national people for the insurance, homeowners insurance, and yet I can't get anything. Can you refer or recommend an attorney as well? Or how do what's my next course of action that I should take?
Okay, well, first thing I'm not clear on. So what was damaged? What was it?
I actually had a huge tree that actually fell across my house, so it destroyed almost half the house. They did pay for the damages as far as trying to put the house back together, but I had a lot of personal items that were destroyed, and my stove and my range and all that kind of stuff was destroyed. Plus, the house was inhabitable, so I had to go. I actually went and stayed with a family member while the house was being repaired because of the water and the wiring and all that kind of stuff.
So yours is going to be a question of what damages are recoverable and what are not.
No,
we're not.
My question is more like, what's my next course of action, because I can't get any information or any response from the insurance company.
Right. It would be to seek legal counsel. We're not permitted to give you suggestions for who to go see, but certainly if you you tap in any search on the internet looking for attorneys involved with either insurance law or homeowners association law, you'll be able to find a number of attorneys there, and you need to give them a call and ask them those questions, because those are certainly things that you need to speak to an attorney about.
Isn't there a South Carolina Insurance Commission as well that you might be able to go to get to the next step answers as to why they're not reacting the way they should be?
There is. There's also the bar has a referral service as well. You could go to the South Carolina Bar website for that.
Right.
Clarice does bring up a good question about trees that I'll ask you about later, but we have Roger on the line with us right now in Myrtle Beach as well. Hi, Roger. Thanks for calling in today. What's your question? Roger, you there?
Yes, I'm here.
Go ahead.
Yes, I live in an HOA in Myrtle Beach, and my question is, I have called numerous times and sent numerous emails to our management company and board of directors, at least within the last 30 days or so, along with other homeowners as well. We are getting no response to our concerns through calls or responding to our concerns through emails or calls. So my question is, what other recourse do we have at this time to get a response from at least the management company who represents our condominium association or the board of directors for our HOA, being that nobody responds to our concerns?
Well, you've taken the step that I always recommend first, which is try to contact them yourself and make repeated efforts to contact your board and your management company. But if you're not getting any kind of a response and there's information that you want, or you feel like something that's not being addressed that should be addressed, then at that time you probably do need to get legal help, and you should probably go see an attorney. I would suggest that if you make an appointment to see an attorney, that you bring your association documents with you, because a lot of times, in fact most times, those documents are going to determine whether or not the concerns and questions that you have are in fact valid and are something that you're entitled to receive. And so that would be my suggestion at this point.
I think that's right.
All right, Roger, hopefully that helps you out. Appreciate you calling in here today. Tell you what, we're going to take a quick little break. When we get back, we'll have plenty of time to get you on the air. If you have any questions about specific things with your HOA or questions in general, please feel free to give us a call. The number's on your screen. 848-8080 is the number right here today on Legal Access. Welcome back to Legal Access. HOA law is our topic here today. Always a lively discussion during HOA topics, but we still have time to get you in, so call before the top of the hour and we'll make sure and get you on the air here today. and get your questions answered. Here on the panel to answer those questions for us today is Mark Napier and also Jared Owenby. So please feel free to give us a call. The phone number's on your screen, 848-8080. Let's go to Myrtle Beach right now. Chris is on with us. Hi, Chris. Thanks for hanging on during the break. What's your question today?
All right, first I want to let you know I live in a community in Carolina Forest. There's 464 homes. Every year when we have our annual meeting, we can never get a quorum. This year probably was down to like the third or fourth meeting, whatever it was. At that point, we didn't need a quorum. But normally we have 5 members on the board. For various reasons, we're down to 3. So at that final meeting, I offered to run for the board, and they wouldn't let me. First they said that you can't have an even number. You have to have, an odd number. So then I said, well, what if I can get someone else to run with me? And they said, no, you can't do that. It's too late. You have to wait till next year. I mean, do they have the right to deny me being able to run for the board?
Well, usually the bylaws of the association set forth, number one, how many directors are supposed to be on the board. Also sets forth the procedure as to what you do when there's vacancies, and sets forth when the elections are supposed to take place. Usually if you have an opening that takes place after an election, there is a provision for them to be able to appoint the next director to finish out the term of whichever director has been either left, resigned, or and for some other reason is no longer in office. But as to whether or not your situation merits further looking into, I think that would be something. Again, I hate to just throw this out there, but look, you need to speak to an attorney. You need to speak to an attorney, give them the details, let them take a look at exactly when this happened in relation to, as really in relation to your situation, and to see whether or not, hey, that we have somebody here who's willing and able to serve, and you're not letting them do it. Why?
Oh, and also on top of that too, the bylaws or the documents themselves may mean that, or say that the annual meeting is the only time that can happen. They may not allow for a special meeting to be called for that purpose. So again, going back to whatever the master documents say really dictates what happens.
Right, because those remaining board members, they really have the authority to
Exactly.
who they want to appoint.
Sure.
So, yeah.
All right, Chris, well, the ball's in your court, so see what you can do, and keep pushing to see if you can run and be a member of that board so they finally have a quorum. Thanks for calling in here today. Let's go to Conway right now. Joe is on with us. Hi, Joe. Thanks for hanging on. What's your question?
Yeah, I'm on the board of HOA, and we totally rewrote our covenants. Do we need to have a lawyer read the covenants, or are we okay because we kind of stayed with the old one and just modified what we wanted to fix?
I mean, I would always say that you probably need to have counsel review that because it may not be appropriate. Additionally, given the fact that any kind of discrepancies or inconsistencies are going to be construed against the drafter, and in this instance you would be the drafter, that might create a bad situation for the HOA in general.
I agree. Those are good points. You definitely should have an attorney look at it, because this is a legal document, and it's going to be, and in order for it to be enforceable, it has to be recorded, and it needs to make sense. I mean, did you set forth why we went from this particular set of covenants to this set of covenants? I mean, what's the reason behind it, and is it described in the document so that if somebody is searching the title, they can find it and they can understand what has happened? These are all things that need to be looked at, and definitely it should be an attorney.
Sure, and additionally, on top of all of that, it may not have been appropriate for you guys to modify the covenants, conditions, and restrictions to begin with, because it may not have met the threshold requirements for an amendment.
Right, exactly.
Thanks for calling in, Joe, and thanks for doing a thankless job a lot of times. Appreciate that. Our phone number is on your screen. It's 848-8080 if you have any questions about your HOA and specifically or in general. Let's go to North Myrtle Beach right now. Phil is on with us. Hi, Phil. Thanks for calling in. What's your question today?
Yes, I was wondering if the HOA board can hold a special meeting called by the members without a quorum of the officers.
So the members called for a special meeting of the members, of the membership? Is that what you're saying, Phil?
That's the way I understand it. Yes.
Okay. So if they do that and they send out the proper notices for, when you have a special meeting, you have to say exactly what the purpose is of that meeting. And the special meeting can only be for deciding that particular issue. You can't add other things. And so that's step number one. And the notice requirements have to be met, and then you still have to get the quorum there, in quorum of the members, not quorum of the board, quorum of the members for purposes of being able to actually have the vote that the special meeting was called for.
That's right. All right, thanks for calling in, Phil. Appreciate that. Still got about 10 minutes if you'd like to give us a call here today on Legal Access if you have any questions about your HOA specifically or in general. As we were talking earlier, as far as changing the covenants or changing the documents, sometimes there's things that were written like 20 years ago, we didn't have verbos or Airbnbs and things like that. But if they wanted to update their documents so that they can have some restrictions against those, has to be voted on just by the board or by the members?
It would depend on what the master documents say. Most of the master documents that I've come across have required any kind of amendment or modification to the covenants themselves to require a supermajority vote of the membership. But depending on whatever the documents themselves say, they will dictate whether that's a function of the board or if it's a function of the membership at large.
All right, fantastic. All right, before we go to break here, let's go to Myrtle Beach again. Deb is on with us. Hi, Deb. Thanks for calling in today. What's your question?
Hi, we submitted an application for a screened-in porch to our home. It was approved, but they put a condition on there that asphalt shingles were necessary for the top of the roof, although the guidelines for any additions there's nothing in print that says shingle roof is required. So do we have to comply with the letter even though the board documents don't have any such requirement in them?
Yes. And the reason, and I know you don't like that answer, but the reason I say that is in most cases, and so I guess I should put a caveat in there, in most cases the ARB documents will have language that says that the board or the ARB can have a certain amount of discretion when it comes to aesthetics and things of that nature. And just because it's not in their general guidelines that they have recorded, I don't think you can just choose to ignore it. I mean, maybe you appeal it. You look to see, do you guys have appeal language available to you when when something is denied or partially denied? I would suggest looking at that first, but I would not recommend just ignoring the specific language of the approval and ignoring that shingle request.
All right, Deb, thanks for calling in, and hopefully you get your screened-in porch built soon enough so you can enjoy some of the nice weather before the winter comes rolling around. If you have any questions, we got about 10 minutes left in the show. We'd love to get you on. Call the number on the screen. We'll talk about HOA law, whatever your questions are here today on Legal Access. Welcome back to Legal Access as we've been talking about HOA law here today. Still got a couple of minutes. We might be able to fit you in. 848-8080 is our phone number here, along with Mark Napier from the Inlet Law Firm. And I forgot to ask you at the beginning of the show, like we normally did, in addition to HOA law, what you guys work with?
Well, we do, we're a general practice firm, so we do real estate closings, we do estate planning, we do personal injury cases, so we do, and we have an attorney who just does criminal law, so a little bit of everything.
Kind of whatever walks through the door.
A little bit
and
of
Jared Owenby's with the Mullins Law Firm, and what does Mullins Law Firm deal with in addition to HOA?
Same type of situation, everything from family court, domestic law, on down to foreclosures, foreclosure prosecution and defenses, civil law, criminal, real estate, so a little bit of everything.
So we're well equipped to take care of your HOA questions here today. Make sure you can get them in, 848-8080. Before we get to our next phone call here, we're in the political season. I know a lot of people like to put up political flags or political signs in their yards. There are a lot of rules with some HOAs that say you can't have signs in your yard. Can the First Amendment be used as a defense about, hey, I've got a sign in my yard, it's my right to be able to do that?
Oh, your rights are out the window once you get an HOA.
Well, I mean, you bought subject to.
Exactly.
That's the important thing to understand is that when you purchase the property, you purchased it subject to these restrictions. I don't know that it's necessarily a First Amendment issue when it comes to a situation where it blanket, applies to every sign, rather than chilling one version or the other.
Well, let's talk about just American flags. I know a lot of people have put up or wanted to put up their own American flag, but we're told no, you can't have any flag of any kind.
They can't. There is a law in place that says the American flag can be flown.
Okay.
So there is you cannot restrict that. They might restrict on the type of pole that it's on, or that it's been lit up, that kind of stuff.
Or where it's located, or things like that.
But you can't deny somebody from having the American flag.
All right, we got a couple more phone calls to see if we can fit in before the end of the show. Mike is in Conway. Hi, Mike. What's your question today?
Well, my question is, I'm on the board of our HOA here in Conway, and we have a new property management that we're with, and they refuse to take the $500 fee out of people who buy a home here in our addition, because they say it's not in our legal documents. But yet the property management we had before for a few years, they were taking it out. So we find out now that the money has been taken out, but yet we have no foundational legal document to have taken it out. Do we owe the people, as our HOA board, do we owe the people who have had money taken out when it shouldn't have been taken out of their money? Do we owe them that back pay?
Well, the $500 that you're talking about, Mike, is that for a certificate of assessment to make sure that the property's in compliance with the HOA documents?
I would imagine it's probably for like capital improvements or something whenever somebody purchases. But I would be very concerned if there was no language anywhere in the documents allowing that amount of money to be taken out from a closing. That is something that your association probably should seek attorney advice on, so that they can specifically look at your documents and give you advice on that. But
also, before I don't want to cut you off, sorry about that, Mark. We have Dawn on the line. Dawn, we only have about a minute and a half left in the show. If you can give us your question in about 30 seconds.
Sure. In 2018, South Carolina passed a law stating that all of your documents had to be recorded at the Register of Deeds by January 31st of 2019. Our HOA, our master deed bylaws were already recorded, but the rules and regs was not recorded until after January 31st of 2019. Are those rules and regs enforceable?
as long as they've been recorded, I would take the position that they are enforceable. If they're supposed to have been done by the night, because if you, for instance, had made changes to the rules and regs, say in October, they would be enforceable even though they weren't yet recorded, but they had to have been recorded by January 19th. So on January 20th, they would not be able to enforce them. But if then by the time they did record them, I think they'd be enforceable. I don't know if the courts have even ever looked at that specific question.
I don't know either. I would take the same position you did.
Don, great question. You know all your facts, and appreciate that question. If anybody has any other questions about HOA, make sure and email us, and we can answer them off the air. Legal Access at WMBFnews.com. For Jared Owenby and Mark Napier, I'm Dave Priest. Next week's show, auto accidents, right here on Legal Access.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the information provided in this program is purposefully broad and does not